in the document, and the third one is whether Mary intended to amend the entire trust in forming the Second Amendment.
Some of these relate to the merits of what they're arguing, and which of these claims are barred by the no contest clause? You said that the first one wasn't.
The first one was they demanded immediate distribution, and I hope to come back and try to clarify your questions, Your Honor, about the distribution, because it seems that I haven't answered what you're trying to get to, and I will try to. Okay, they're demanding immediate distribution, and our position is that the trustor's intent was that the conditions for distribution have not been fulfilled, so they're requesting distribution in a manner that is contrary to the intent of the trust document. The second one is they have said that Mary did not have any authority to amend the decedent's trust. Our position is that the intent that she expressed in the Second Amendment was that she intended to amend the entire trust. She doesn't specify subtrust. And then the third claim is whether or not there was a breach of trust for her failure to establish a subtrust, which I'm not sure what that has to do with my clients anyway, because that would have happened 2.5 years before they became trustees.
Well, counsel, I'm still having trouble. Where in the original family trust does the survivor have the right to amend the first decedent's subtrust?
Once that subtrust is formed, she doesn't have that right. Our position is that she didn't form the subtrust.
So the survivor can simply not form it and totally frustrate the husband's expressed desire.
No, because the husband...
It seems to me that oftentimes you have situations where you have maybe a second marriage, and you have children from the husband, and you have children from the wife. And when they see an estate planner, they want to make sure that their half of the property ends up with their own children. And as I understand your argument, even though the family trust does not provide expressly that the survivor can amend the decedent's trust, nevertheless, the survivor can just simply elect not to form it, and accomplish the same thing indirectly. Am I missing something, or is that...
No, but you have to realize, you talk about the surviving settlor frustrating the decedent trustor's intent.
Yep.
Well, the evidence we have here is that preventing litigation was very important to the husband as well as the wife. So she made a choice there. She could go either way. And based on the evidence we have, the steps she took enforced his intentions also. It was the intentions of both of them carried. So, she had a choice at that point in time under our reading of the trust.
So you're saying under your reading of the trust, when Rodney died, Mary could do whatever she wanted with the family trust, regardless of Rodney's stated intentions to maximize the federal estate deduction, and also to leave half of his community property and all of his separate property to his children.
Well, she had a choice. Under our reading of the trust, she wasn't required to set up the subtrust on the death of Rodney Donkin.
Which would give her the ability then to change how Rodney intended the distribution of all of his separate property and half of his community property.
Correct. And the language of the Second Amendment indicates that that's exactly what she didn't intend to cut out the beneficiaries, but she did intend to amend the entire trust.
So Rodney's intent becomes irrelevant?
Well, again, Rodney's intent was also to prevent litigation. This is a family that had a history of litigation. So, and there were things that are not in the record, but we have more evidence that he wanted to prevent litigation than that he wanted to save estate taxes. What do we have other than the clauses in the trust that as evidence that saving estate taxes was their primary objective? We don't have any evidence of that. And so those are the three things, the three items, the three claims that the Court of Appeal found to be violations of the No Contest Clause. I would just say one other thing too, that the transferor's intent is the preeminent factor in determining the legal consequences of testamentary documents. The importance of the transferor's intent has been pervasive through no contest litigation, and I really think it is the reason why courts have upheld no contest clauses. The position that is advocated by the beneficiaries would affect in fiduciary abuse no contest cases would eliminate the trustor's intent by merely alleging fiduciary abuse. That would be overridden, and that would be a huge mistake, and it would fundamentally alter our concept of ownership, because owners of property have the right to bequeath their property to whoever they want on whatever terms they want, just or unjust, as long as they don't violate public policy. So I would just encourage the court to stay focused on those three claims that the Court of Appeal found to violate the No Contest Clause. Thank you.
Thank you, Mr. Snow.
Briefly, Your Honors, first off, I would point to my reply brief on page 4, where I did specifically cite the provisions in the trust that talk about mandatory allocations between the trusts. He indicated that I had not pointed to anything in the trust documents. I did on page 4 of my reply brief. The trustees shall divide the trust into separate shares, for example. Further,
I trust at some point you're going to answer opposing counsel's argument.
Which argument?
That Mary gets to do whatever she wants, regardless of Rodney's intent.
Well, I believe that is a completely false statement. I believe that is not supported by the document. I argued that extensively in my brief, that, as Justice Baxter indicated, oftentimes the decedent and the survivor do have different distribution objectives. In this case, they had one objective before Rodney died. Apparently, subsequent events caused Mary to change her mind and want to do something else. She had that right. We've not objected to that. All we have said is that she did not have the power to control the distribution of the decedent's portion. If I say, I leave at my death black acre, green acre, and white acre, and I never own black acre, does that give me the right to, create some kind of a lien or enforceable obligation against black acre? I think clearly it does not. And Mary did republish and recognize existing trust document in that amendment that we're talking about, the Second Amendment. If I can move on with regard to the Court of Appeal decision, the Court of Appeal did say that we challenged Mary's failure to allocate the trust at the first step, between the different shares rather. And if you read the petition, in Appellant's Index, page 237, we specifically assigned that failure to the respondent trustees, or appellant trustees, Rodney Donkin Jr. and his wife. We're not challenging what Mary did. As I said, surviving spouses often don't do anything at the first death because they don't perceive they have an obligation to do so. But it's incumbent upon the successor trustees after the second death to clean up that situation. That they did not do, and they still claim that there's been no allocation to the decedent's portion as of the last accounting in 2010.
So I understand you to say it's not uncommon upon the death of the first spouse, with direction in the trust instrument to create these subtrusts, that it's often doesn't happen until the death of the second spouse, and then it falls to the successor trustees to basically execute the intent of the entire document?
Well, actually what happens is the IRS assumes that there was a pro rata distribution. If the decedent's portion was 40% of the trust estate, and they assume a pro rata portion, 40% of each asset was allocated. In other words, it's in kind between the two trusts. So for federal tax purposes, it's presumed to have happened even though there's been no formal document prepared saying that this is in the decedent's portion, This is in the survivor's portion. The position of the trustees is that there is nothing in the decedent's portion to distribute because we haven't done it yet. We still have to pay debts. And with regard to the debts, they simply could have provided for these debts by selling properties. They've just refused to do that. And in fact, Mary died in February of 2005 when the market was very strong. It got stronger between 2005 and 2008. They still didn't sell these properties when they could have taken care of all the debt situation with this trust by simply liquidating, which is what most trustees do. And the final point I wish to make is that Mr. Snow indicates that the only thing they were concerned about was defeating litigation, preventing litigation. The trust indicates, yes, they were interested in preventing litigation, but they were also interested in saving taxes. So I believe the court is required to interpret the document as a whole and not to simply look at one provision, to weigh one provision against the other and give one more weight than the other. I believe that they had dual objectives. We are challenging the actions of the trustees after the second death, which many cases say are privileged. And there are a few cases that say they're not. But we believe that cases like Ferber were wrongly decided, that they encourage fiduciary abuse, that the legislature recognized that and enacted 21305 2 years later. And then in 2010, obviated that entire scheme to clearly delineate what kind of claims violate a no contest clause. So with that, I will submit the matter. Thank you, Your Honor.
Thank you, Mr. Boykin. Mr. Snow, the matter is submitted.
All right.